Mr. Wagner, are you appearing before the state?
Yes.
This is the time set for sentencing. Good.
Excuse me, how you doing?
No, I'm talking now.
Okay.
Listen to me. Is your true name and your complete name Shayna Marie Blackshire?
The court lacked jurisdiction over the subject matter.
What is your date of birth?
The court lacked jurisdiction over the subject matter.
The court will accept the court, based upon a verdict by the guilty in this case.
The court lacked jurisdiction over personal addiction.
As a result of a jury trial, the court finds the defendant is guilty in CR 22209. Count 1, unlawful flight from a law enforcement vehicle, a Class 5 felony. This is in violation of ARS 28624C.
Y'all cannot force me to get sentenced.
Yes, I can. ARS 28622, ARS 28622.01, A1, 28624C, 283001, 283304, 283305, 283315, 13701, 702, and 801. The date of the offense was on or about February 5th, 2022. The offense is non-dangerous, and I'm finding it non-repetitive for reasons I'll state on the record. Count three, that she is guilty of count 3, criminal damage, a Class 1 misdemeanor. It's in violation of ARS 13-1602A1, 13-1601, 13-707, 13-802. And she's also guilty of count 4, burglary in the second degree. This is a Class 3 felony in violation of ARS 13-1507A, 13-1501, 701, and 702, and 13-801. The date of the offense was on or about February 5th, 2022. It's the judgment of the court that she's guilty of count 5, resisting arrest, a Class 6 felony in violation of ARS 13-2508, A1, 13-701, 702, and 13-801. The date of the offense was on or about February 5th. The offenses are non-dangerous. I'm finding them I'm finding you're your own lawyer. He's not your lawyer. He's nothing can do it. I'm finding that they're non-repetitive because I believe that these cases, all of the charges in this case and in CR 2022-208, which is the prior case for which the defendant was convicted, these cases all of those charges could have been brought together and tried together, but they weren't. I'm not criticizing the decision. It is what it is. It happened for independent reasons, but I'm finding that they are not repetitive. All right. So, Mr. Wagner, do you want to be heard on behalf of the state?
I do, Your Honor.
And if the victims wish to be heard, we have victims here in the courtroom. A victim, I think. I'm not sure.
No, Your Honor. She's outlasted the victims.
She's outlasted the victim. Do you wish to be heard?
The victims have had to return back to their homes in Oregon, and they're not here, which is a detriment to them. They had as much a right to be here as she did.
All right, buckle up, because what you're about to witness is not your average sentencing hearing. This is a full-blown courtroom collision between reality and delusion. On one side, you've got a judge doing exactly what judges do, applying the law, reading verdicts, and happens when someone confuses internet pseudo-law with real-world consequences. And here's the twist, this isn't trial. That already happened. A jury already decided guilt. Today is sentencing day whether the defendant likes it or not. But as you're about to see, she has absolutely no intention of cooperating, acknowledging reality, or even letting the judge finish a sentence without interruption. So pay attention to how this unfolds. Watch how the judge stays measured. Watch how the legal system responds when someone refuses to participate. And most importantly, ask yourself, does denial actually protect you from consequences, or does it make them worse?
208, Your Honor. She was taken into custody for 208. She made bond and was released on bond, and then she committed these separate offenses while on felony pretrial release.
I just want to make clear, to save your words, I do intend to impose the enhancement of 2 years for the crimes being committed while on release. So I just want to...
All right, thank you.
If there was any confusion about that, I wanted to straighten it out. I apologize for interrupting you, but I thought it was something to clarify up front.
This is illegal.
I believe that it's more than warranted. She was sentenced. Those were separate cases. She was released from those cases, and she committed the new cases. Not only did she commit these crimes separately from the other crimes, these crimes significantly, especially the burglary, I believe substantially affected the victim. The victim, the owner of the property at Morningstar Ranch. Yes, she was burglarized before. No real property was taken from there. As you heard, you sat through both trials. But in this case, in this burglary here, count... Count 4, Your Honor. The defendant confronted the victim at her home and has substantially affected the way the victim feels about her safety and security at the home, which I think is very important, Your Honor. The unlawful flight from law enforcement. And count 5, the resisting arrest counts, are not in any way connected with the prior the 208 case. They're separate victims there. These are definitely separate incidents. The state would argue that as well for count 4, the burglary, Your Honor.
Here we go. This is the cornerstone of the sovereign citizen playbook. The court lacks jurisdiction. You'll hear it over and over, almost like an incantation. But here's the reality check. Subject matter jurisdiction means the court has authority over the type of case being heard. This is a criminal court handling criminal charges. That box is checked. Personal, it's how confidently it's delivered despite being legally meaningless. The judge isn't confused. The court isn't shaken. This argument has failed thousands of times before, and it will fail again today. But notice the emotional undertone. Interruption, refusal to answer basic identifying questions, and an immediate attempt to seize control of the room. This isn't legal strategy, it's deflection. And as we'll see, deflection doesn't stop sentencing for...
A reference to the 2-year enhancement, I can't remember that.
It is, I'm sorry, Your Honor, it is 708D, and I don't know that I made that entirely clear, but it just, whatever the sentence, the court prescribes, each sentence gets a 2-year enhancement.
Is that ARS 13-70708?
Yes, I'm sorry, ARS 13-708.
But not as to the misdemeanor, obviously. Not
as to the misdemeanor. I concur with the misdemeanor assessment that probation had, that it's just time served in the county jail, that she's already fulfilled more than the requirement for that. I agree that the presumptive terms are warranted in the other cases as well, Your Honor. I would point out that the jury during the aggravation phase, the jury found 4 aggravators. They found 4 aggravators. We have no mitigators here that I can see. Even with all of that, I would still ask for the presumptive terms as a Category 2 repetitive offender with the enhancements for the 13708D. I think that these charges probably would be warranted to run concurrent with each other, but I do feel that they should run consecutive to the defendant's prior case. She caused more harm and more emotional stress to the victim, the owner of the property, and then we have separate victims as to the resisting arrest charge and the fleeing from law enforcement charge, Your Honor. I don't have anything more to add than that, and there's no victim's presence. There's some representatives, some neighbors, some people from the Morningstar Ranch that are still living in the area. They're present here today just to watch, I suppose.
Very well. Thank you very much. All right, the court imposes a sentence as follows. As to count 1, unlawful flight, a Class 5 felony, the court, as I said, finds the offense to be non-repetitive, non-dangerous. The court imposes the presumptive term of 1.5 years in the Arizona Department of Corrections. The court imposes an additional 2 years sentencing enhancement because this offense was committed while the defendant was on pretrial release, and that's pursuant to ARS 13708D. So the total sentence as to count 1, class 5 felony, is 3.5 years. As to count 2, this is the misdemeanor criminal damage. The court imposes a sentence of time served. As to count 4, again, the court finds this to be non-dangerous and non-repetitive. This is burglary in the second degree, class 3 felony. The court further imposes the sentencing enhancement as required by law under ARS 13708D for 2 years for a total of 3 years as to count 5.
If you enjoy content like this, make sure to leave a like and subscribe to the channel. It really helps me out a ton, guys. Let's get back to the video.
The court further designates that the sentence imposed on counts 1 and 5 are to run concurrent with each other. That is the unlawful flight and the resisting arrest. The sentences in counts 1 and 5 are to run concurrent with each other. The sentence imposed on counts 1 and 5 are to run consecutive to the sentence imposed on count 4, which was 5.5 years as to burglary in the second degree. So the sentence imposed on counts 1 and 5 is to run consecutive to count 4. The court imposes the sentence imposed on count 4 in this case, which is burglary in the second degree of 5.5 years, is to run consecutive to the sentence that was imposed in case number CR 22208. Right, so the sentence imposed as to count 4 in this particular case is to run consecutive to the sentence imposed in case number CR 22208. That's because this defendant was released in the prior case, 22208, when it was a justice court case. She was released when she posted bond on July 7th, 2021. She failed to appear and a warrant was issued for your arrest on October 20th, 2021. The events in this particular case are alleged to have occurred, I believe, on February 5th, 2022. So the events that happened at the Morningstar Ranch that were the subject of 22208, do you wish to have an attorney appointed to represent you on the appeal? If you cannot afford to pay one, the court will pay the cost of an attorney to represent you on appeal. That will include the cost of the lawyer's legal fees and legal costs. You will not have to pay anything. Do you wish to have an attorney appointed to represent you on the appeal? No. Appeals are specialized actions, and Court of Appeals is very sticky with their rules. They're very strict, and it's a real specialty with someone who knows how to write good appeals. I met with you before when you were here before, and we met not in chambers, but in the holding cell area. It's all on the record, what I'm referring to, and I advised you that it really is in your best interest, I believe, to have a lawyer represent you on appeal, and you indicated at that time that you don't want a lawyer to represent you on appeal. I'd really encourage you to do it. I think it's in your best interest, but it's your choice. Okay. You're excused. You're remanded to the custody of the sheriff to be delivered to the Arizona Department of Corrections to fulfill a sentence. What? Hold on a second. What?
How much time did he give you? You just said a whole bunch of numbers.
Yeah, you can take them. You're excused. Thank you. Good luck. All right. I'm not having the defendant step forward to sign for notification of her rights and to sign the judgment in this particular case. She's consistently throughout all the proceedings in the Justice Court and in this court as to whenever required to do so or asked to do so, refused to sign anything. So that would be fruitless to ask her to do that. But the record will reflect that.
At this point, the judge is methodically reading through each conviction: unlawful flight, criminal damage, burglary, resisting arrest. This is not commentary. This is the formal legal record being established. And while the judge is calm and precise, the defendant's behavior is doing the opposite: interrupting, complaining about restraints, refusing to participate. Outcome: the convictions still stand. The findings are still entered. This moment highlights a hard truth a lot of people learn too late. Refusing to engage with the system doesn't make it disappear. It just removes your ability to influence what happens.